America's founders embarked on what was a radical experiment, of course, a government of, by, and for the people, ruled by laws and based on the self-evident truth that all men are created equal and free. That experiment transformed 13 disparate, distant colonies from the world's largest empire into what became the world's freest and most successful self-government in human history. For Americans, this year is not simply a celebration, it is an invitation to come together and to ask what we are doing in our own time to preserve and fortify that experiment and all of the blessings of liberty and opportunity and security that we enjoy today.
A Synopsis of Constitutional Law by Redlich 2002, Chapter 2, Congressional Powers. Looking at the origins of the legislative powers of the United States, the federal conflicts between the national and state governments pertaining to various constitutional issues, and how Congress's powers interact with the fact that the federal government is limited and enumerated. The first topic discussed is the Supremacy Clause, an overview, and I quote, on page 82, the government of the United States then, though limited in its powers, is supreme, and its laws, when made in pursuance of the Constitution, form the supreme law of the land. End quote. That means the laws passed by Congress, if they follow the Constitution, if they are constitutional, are supreme over any state law. The next topic covered is the necessary and proper clause, its meaning and example. I quote, only as may be necessary and proper for carrying them into execution. Page 84, end quote. That means Congress may use any necessary and proper means for carrying their constitutional duty into execution, into fruition. Another quote, and I quote, Marshall suggested that Congress could constitutionally employ all appropriate means plainly adopted to achieve legitimate ends consistent with the Constitution. End quote, page 89. An example of this is in the McCullough case. This represents the classic example of structural constitutional arguments. What do the structures infer? And in the debates surrounding the necessary and proper clause, many use the structural constitutional argument. What do the structures infer to point to what is necessary and proper for Congress to enforce the constitutional powers? The next topic is the commerce power, the meaning, exploration, and examples. And in this is what people interact with on a daily basis. This is what people really most recognize as a power of Congress, the power to raise taxes, formulate a budget, and so on. So let's get into this. So the commerce power is the power to regulate navigation. I quote, it's the power to regulate, that is, to prescribe the rule by which commerce is to be governed. End quote, page 92. Regulating commerce pertains to foreign and multi-state or interstate movement of goods, not the internal or intrastate commerce, which is a state power in our federal system of government. It is important to also recognize that manufacturing and commerce are separate. They are two different things. Manufacture is to transform, and commerce is to buy, sell, and transport goods. Another aspect of this topic is dual federalism. Federal government and state government operate in distinct spheres of power. And that is why there's a difference between interstate movement of goods pertaining to the federal government and internal or intra-state commerce pertaining to state power. They're two separate powers in our dual federalist system of government. And it's also important to explain on a side note, we have dual federalist aspects of our government. We also have cooperative federalism, which are the different levels of government working together. But let's get back on track. Another question that is raised in the commerce power of Congress is, does the power to regulate include the power to prohibit? I quote, Congress may exert its prohibitory authority to reach commerce it may reasonably deem injurious to public health, safety, morals, or welfare. End quote, page 105. Congress has the authority to prohibit trade if it deems harmful to public interests. That's basically what that means. But this is the important part. Mere intent does not automatically grant federal authority to regulate. Manufacturing is local, and selling, shipping, and contracting to ship outside the state is interstate commerce and falls under congressional power to regulate. One of the core court decisions, judicial decisions in affecting Congress's commerce power is the United States versus Darby 1941 case, which presents two main questions. The first being whether Congress has constitutional power to prohibit shipment in interstate commerce of lumber manufactured by employees making below the minimum wage. The second question is whether Congress has power to prohibit the employment of workmen in the production of goods for interstate commerce. Another core constitutional case in the courts pertaining to the commerce power of Congress is the Wickard versus Filburn 1942 case, which surrounds the idea of price regulation. I quote, "It is well established by decisions of this court that the power to regulate commerce includes the power to regulate prices." End quote, page 130. And all of this that the courts are employing, they're employing a determinative test to verify Congress's commerce power. And that test involves two criteria that Congress has to pass. The first being, do their actions, does the legislation concern multiple states, which around their interstate commerce regulation, their ability to regulate that, which falls under federal authority. And two, do their actions, does the legislation they are attempting to pass concern national interests? Those are the two main criteria that courts will be looking at in cases concerning the commerce power of Congress. Another topic is the taxing power, the general welfare and debate. General Welfare Clause, Article 1. And the General Welfare Clause can be found in Article 1, Section 8, Clause 1 of the United States Constitution. This basically means the power of Congress to lay and collect taxes, duties, imports, and excesses, to pay debts, and provide for common defense and general welfare of the United States. And in this power to tax, there is an argument between our founders, even between the Federalists who wrote the Federalist Papers, and those two Federalists are Madison and Hamilton. Madison stated and argued that the taxing and spending must be confined to the particular powers explicitly granted to Congress, employing a strict construction of what the text says. Meanwhile, Hamilton, he states and argues that the General Welfare Clause granted Congress a substantive, independent power rather than confined to tax and spend. Hamilton, unlike Madison, believed this power was not limited by specific powers enumerated in Article 1. The next concept is spending power of Congress, the limits and its history. Spending power is tied to the general welfare powers of Congress, meaning the spending power of Congress is not unlimited. It has to follow the text of the Constitution, the general welfare aspects of it. The practice of conditioning funds also falls under the spending power of Congress, and this is a long-standing practice by Congress. Congress can encourage or directly condition federal funds to states in order to push a policy or activity. The conditioning of funds must be 1. Clear, 2. Related to the purposes of the funds, and 3. In pursuit of the general welfare, and lastly 4. Not unconstitutionally coercive. So it has to meet the clear, related, and in pursuit of general welfare to try to get past the unconstitutionally coercive aspects of withholding funds. An example is President Clinton pushed results under the Gun-Free School Zones Act, in which Congress can encourage states to ban guns from schools by linking funds in order to execute and push that act into realization. And the last topic is the treaty power, its relation to federal system. And the treaty power of Congress really only pertains to the Senate as the upper chamber that approves and shows as advice and consent to the president on treaty and foreign relations. And treaties are treated as a supreme law of the land, similar to a statute passed by Congress. Treaties override all conflicting state laws as a result.